talking about that.
Yes. On and on. G.
What you want?
Mine just came up with that. Arrow.
G. What you want?
I go like, hey guys, what's going on here? I said, oh,
It's be too cold and
yeah.
Okay. Email this one because I don't know. So that's why I said email me.
I read it to them. No, y'all sleeping.
Give me the question. I just wanted to just
like the different reviews, like one was the 2008 FAT yeah. And if you search for that was only right.
Something that I gotta get started. I can't do it one night.
you better put your condo on. Yeah, that's
That's all I have to say, right?
I opened that. I said, what's going on here? Oh my God, I said, it's supposed to be safe. I saw it, I didn't think I would have said it. That kind of hurt my feelings, but I was scared. I'm there, I'll take your stuff off. I do nothing.
Hey, G. Okay.
Did you believe that?
She said she's going to do it. I think next week.
you know, where
Not a second one. I could
or to know what's the difference between Portugal and Australia. That was part of it. Before we even get there. Yeah. You even bring it to them like this. This is scary. Why are you in the back here holding up the wind? Yeah. Chocolate. The one here? Yeah, and the third drive was just I know what you're saying. I'm not going to yeah. So, the new one, that's like I said, so yesterday I knew I did have that limited. I started to build a framework. I think last week. That's horrible. Yeah. Yes, I was last week.
No, they were
incorrectly wired? Oh, so we send you because you can't do the whole
listen, when you watch this one,
but then when I see it all, it's not a good. Yeah, because it's not great. Oh no, I forget that. I'm sorry, because number two speech. See, I did one. But she shouldn't have done what she did. Yeah, she was wrong. Oh, yeah. No, but she was not approaching the white. No, she was not approaching.
This is controversial, right? This was the show. And this is going to make us a good day. This is going to make us a good someone you listen to number two speech first. Last night she had me feeling. I read it. Oh, Lord, you that's how convincing she was. That's how convincing she was. She was thinking a younger girl. I felt so inspired by that. Listen to me. That's my I was like, what are you doing? She comes in the back. I was sitting next to my last and I was like, I thought you sleep. I was just like, tell me what it was. He said Sarah's mom. Then I went inside. All the things. Like what's insurance? Yeah, this is what's education.
Yeah, somebody. I was trying to provide. Yeah.
Even last one, but and you have a degree in security.
So that could be insurance.
Yeah, 2 hours.
I forget, that's how small it was too. Like 6 hours.
At the beginning.
At the beginning.
To feel the crowd. And then they go in.
So you have to catch up
2 hours. 2 hours next week. I see I will help in that I speak to girls from church. We sit down like every 2 business days. Not next Tuesday. I can tell them that now. Do you ever see anything like that?
Did you?
That was the last one.
It's been 5 years.
so much things to do with.
You were in there 5 years.
I feel like they interrupted my TV.
Yeah. Yeah. That's what cost me.
I'd like to do some of this in my essay.
Yeah, I just want
A+.
I was like, that's the way, but I got more
Back home. I gotta call like back home. You wanna put it up
On the screen. At the same time. From that one.
So put that question on there. Right away. Coming down from Spain.
I got a copy of your assignment. I've been looking at it. Actually, it's quite good. Something you can sing and take it to.
You think that's where it's going?
You gotta cut it down.
It takes long though.
If you were looking at it, if you have the last copy of the revised AML guidelines, all that's doing is talking about your question. People, so everybody could hear, and I'll do it repeat. The AML guidelines on our website is what you need for your question. I mean, if you could, you know, like how in school when you had a essay to do and paraphrase and put in your word, you're always free to write everything. Now, your challenge will be to condense it to the amount of words, because they want you to do a risk analysis on the firm and then make recommendations. We'll be doing next week. We have to complete the CDD portion, and that'll give you some good insight as to what you to look at. But this is a good question. This is a very poor excuse for compliance system, and this is what we don't want in your organization, having the business head over compliance program. You have to have, that's the first rule. And you need to go to our corporate governance guidelines. If you're in insurance or securities, it's very good. You could apply it to your industry. The corporate governance guidelines, we actually have a test of independence in them. one of the things we do not like to see in our lives is the market people, the business people, over the compliance function. You just can't have that. That's a pure conflict of interest, and that's what they have here. That's probably why the system is so poor. There needs to be independence in the compliance section. If you haven't looked at it yet, the compliance function by the Basel Committee of Banking Supervision, you need to download that and look at it. In the Basel compliance function, the paper written by the Basel Committee on Banking Supervision. Again, don't be thrown off just because it's a bank. It's applicable. You can take from it the insurance or securities or the FCSPs. You just water it down and make it relevant to your system. But it'll give you some good insights as to what's wrong here. Okay?
So it's the compliance function.
Compliance function. It's a paper that they did on the compliance function. By the Basel Committee on Banking Supervision. And of course our AML guidelines. This maybe today I took some time just to go back and review it because I was at the beginning of the guidelines. I've been into so many other stuff, but it has been revised recently. We've taken some revisions that we were looking at, but it will be revised again. But probably not this year. You're all working on that yet with legal, right?
Yes.
With the FATF revised.
Yes.
Yeah. So when they finish their review and consulting with the GFSR members, that's the group of financial regulators, which will include the FCSPs, the insurance, and the securities, then it's going to be revised again to take in any amendments we need to because of the 40 that's now in effect, every tier 40. But it's a very, very good guide as to what's wrong here.
Sorry, I know FIU is smart.
But we don't know. We don't know. Okay? But those with the securities as well, you all Securities Commission have some as well. And it'll probably be basically the same things being picked up from our, we pick up in our AML guidelines as well. But this is a very good question. We really sink your teeth into it. Okay? But,
Yeah, we just thought it should have come at the end of the course.
you will do the CDD next week, and then you have what, 2 weeks, 3 weeks? Before you give it in? 2 weeks, 2 weeks. Anyway, I'm getting into the class next week. Let me just finish what I have here. But, that's the gist of a little bit on right now. Regine, you don't have good CDD. Okay. I think I went through basically some of the acts, just a brief overview. And this is the Proceeds of Crime Act. This is the Umbrella Act. That's over the whole system. Everybody's included in this. And of course, this came into effect December 2000. It has been, I believe, some amendments, but basically it should be the same. The substantive provisions. And just a note, our system is based on the UK model of reporting transactions, business transactions, rather than the US style currency reporting regime. We didn't have the manpower at any rate to look at the hundreds and thousands and probably millions of CTRs that the US got, so we wanted based on suspicion to at least give some leg up on the investigation, because if the entity that's submitting it thinks it's suspicious, then there might be some fire where smoke, you smell smoke. So we have the STR system. Again, our first money laundering attempt legislation was Tracing and Forfeiture of Proceeds of Drug Trafficking Act, enacted in '87. And of course, that's the seizure, confiscation, proceeds of drug trafficking. The act was replaced by this particular act, okay? And it broadened the scope of crimes. Under here, then we got Prevention of Bribery Act,
The offenses that we're going to be talking about a little bit tonight, 40, 41, and 42 of this act, which pertain to money laundering. An offense tried on information in the Bahamas other than a drug trafficking offense. An offense committed anywhere that, if it had occurred in the Bahamas, would constitute an offense in the Bahamas as set out in the schedule. So if it was an offense here in the Bahamas, then you caught. If it wasn't, and that's tricky, because a lot of times persons ask, well, did we have anything that we could assist if we didn't have the TIEAs with respect to tax? And there's a back door. The lawyers might know about it because it's fraud. If a client is defrauding its government and the government can bring the evidence, we have a fraud statute. So they could be successful under fraud. So we did still have some kind of opening for foreign governments that consider themselves defrauded by their citizens. I don't know of any cases, but it could be successful under a fraud statute. Okay. Under our Proceeds of Crime Act, the term criminal conduct includes drug trafficking, bribery and corruption, money laundering, any offense which may be tried in the Supreme Court of the Bahamas other than drug trafficking offense, and it's the same thing. An offense committed anywhere that is committed in the Bahamas, okay? But that's the criminal conduct defined. Now, with respect to substantive money laundering offenses, again, they usually comprise an actus reus, it's the only part of the law, I will say, or act at a mens rea, legal language. I like to say that because I said, you know, people say, well, do you know anything? I said, no. Let's go. Natural element. The offenses may broadly be described as follows. Transferring or dealing with Proceeds of Crime Act, and that's section 41A. Person is guilty. I hope this works tonight. If he transfers, sends, delivers to any person or place any property which in whole or in part, directly or indirectly, represents his proceeds of criminal conduct, or disposes, converts, alters, or otherwise deals with in any manner and by any means that property with the intent to conceal, or disguise such property. That's the act itself. And you can see it's very broad. So it captures anybody who's receiving or actually doing the activity itself. That's the act, and of course it has the mental elements. This going on there. 42, a person is guilty of an offense of money laundering if knowing, suspecting, or having reasonable grounds to suspect, the mens rea, that any property in whole or part, directly or indirectly, represents another person's proceeds of criminal conduct. Yeah? If he uses, transfers, sends, or delivers to any person or place that property, or disposes or otherwise deals with in any manner by any, come on guys, by any means that property with the intent to conceal or disguise such property, that's the act itself. 43, this deals with concealing and disguising again. There's a lot of concealing and disguising and disposition. The whole thing deals with the money laundering offenses, and these are the ones that we will be looking at. Okay? Now, this is where professionals usually, 40, Section 40 itself deals with the person who commits the crime. Okay? So you can put a note if you want to. Section 40 deals with the person itself. And he is trying to convert and divert and sends and delivers. 41 deals with the professional. These are the professionals that he needs. Okay? The lawyer, the accountant, the FCSP, the bank, the trust company, whoever he's dealing with. So assisting another to conceal proceeds of criminal conduct. And you're guilty of an offense if he enters into or otherwise concerned in an arrangement whereby you're doing, or should I say, creating a complex structure, or maybe a simple structure, where the control is retained by the person who committed the crime. Okay? That's why, as professionals, we need to be very careful in carrying out our CDD. If anybody read forward into next week, you'll see a lot of examples in there where persons should have been more careful if they had dug a little deeper. And they're talking about unraveling structures, because you need to get down to the natural person, to the individual, no matter what the structure is. And that is why the, I forget which recommendation, but the new 40, I think it's either 12, talks about in the CDD that you need to get down to even past the registered, and we were talking about nominees last week, even past the registered ownership that is in the registrar of companies or wherever it's listed as a company, or of course we don't list trusts, but if it's a company that is a part of the trust assets, who own it? Yes?
How does that then relate to the understanding of the agreement under legislation as it relates to Schedule 1 countries?
No. One thing you would find out that you cannot outsource your obligation under the Act to know who you're dealing with. You just cannot do that. In our guidelines and public securities as well, we say that you have to get enough information to be able to. How are you going to monitor on their say-so? You have an ongoing monitoring obligation, and that was put in because we were cited, I think in 2006, that we didn't put, I guess it was assumed that you would have ongoing monitoring, but it was not explicitly stated. We put in an amendment to explicitly state that there have to be an ongoing obligation to monitor. And that's why you had, I think we had a bit of a compromise in our AML guidelines, I'm not sure if the securities carried over into theirs, that you can open an account for somebody, but you cannot transact across that account until you have gotten enough information to be able to monitor that individual or that company's activity. So I believe we said 30 days or something like that. You, after opening the account, you need to get the information. You have to know who you're dealing with. And I know where you're coming from. Head office shares the client with you. No? Or if you're standalone, you are...
Hypothetical, if you have a company that's opening an account with you, but their IBC or their company is domiciled, let's say, in Barbados. Barbados is expected that they have the same level of AML and whatnot as us. So on your declaration of BO, the company, another company is listed, but you do not know who the physical person is because they are applying the Schedule 1 guideline. That's an offline discussion.
yes, because the Schedule 1 is
being
not
interpreted incorrectly in that
well,
regard.
it's not meant to take the place of your review. Let's put it that way. It's not meant to be like that. It's meant to give some level of comfort that not IBCs. It's thinking about financial institutions from Schedule 1, not clients from Schedule 1. It's financial institutions from Schedule 1 countries. Because the financial institutions, we have more comfort because they have to be licensed, they have to be reviewed by that regulator, and if that regulator, that country has regulation on par with the Bahamas or above, then that's the comfort. Not the companies and the people who live in Barbados just because they're in Barbados. No. That's the wrong interpretation. That was because of licensees. We are saying that there should be some comfort. Yes. No, not clients. Okay. Let's see, retention control. Okay. Yes. So that's the act itself, and like I said, professionals need to be very, very careful when they're dealing with these activities, these persons, these entities, because they need to know who they're dealing with. There was a case where a young lady, even here in the Bahamas, where they were doing some business for a client who was a client of a trust company. And the trust company refused to give them the documentation. And in that setting, I said, well, they needed to really talk with the trust company. It is a licensee. They probably a licensee under the FCSP. They need to come to some kind of agreement, because even though it's a licensee, yes, I guess they can have some comfort that they're licensed by the central bank, where the client is the primary client. They have secondary business with the FCSP. They need to be very careful, because the obligation to monitor is on them as well. So it's a tricky situation there, because they should give them something, not just a letter saying, well, we have all the documentation and rely on us. You see what I'm saying? I see you itching to say something.
FTR or your FTR, I don't remember it. I think that's what you're referring to. To get a confirmation from the financial institution via the jurisdiction, basically saying that they have done the due diligence.
Yeah, but under our act, you cannot. It doesn't fully mitigate your obligation under our act. You see what I'm saying? It doesn't. That came up before. Okay. So you're guilty if you're found to be assisting with the potential control on behalf of another, and also under B, A's proceeds of criminal conduct are used to secure that funds are placed at A's disposal or are used for A's benefit, and he knows or suspect or has reasonable grounds to suspect that A is a person who is or has been engaged in or has benefited from criminal conduct, you're guilty. And a lot of times you have, as professionals, sometimes we unwittingly get into situations that we don't know, but halfway through it, if you do know, then you are bound to report. We have a couple of, over the years, especially when we were the depository for SDRs, you would have professionals call us from the banks, trust companies, and they would say, well, we did not book the account. Should we still file? I said, yes. Because what does the act does not exonerate you from filing. It said if you know, suspect. It didn't say if you booked the account. Did it? It said if you know or suspect or have reasonable grounds to suspect. And you should get enough information to assist the investigation. Because that's the only way during your investigation that you would have come to the knowledge or come to the realization that this person is a bit shady, I'm not going to deal with them or whatever. So you need to be very careful here. It's not just your organization. That person could go down. Where is it? Oh. The person could go down the street to somebody else and get into the system. The problem here is some people are so locked in to just their institution that they forget it's the whole system. Because it's not just your institution. If something happened to the company down the road, or in Life Key, or wherever they are operating from, we're in one center. And you only have to look at Cayman. BCCI was a big blow up, money laundering across borders and whatnot, and Cayman had a big entity there. It wasn't the other financial providers, BCCI was the one. But who they keep talking about? Cayman, Cayman, Cayman. So the reputation is everybody's concern, okay? And that is why you should and have to report if the matter comes to your attention, not just because, you say no to them. Okay, 41.2. These are safe harbor provisions for the professional. Provides for safe harbor from civil or criminal liability for disclosures made pursuant to the provisions of this act. provides where a person discloses in good faith to a police officer the suspicion or belief that any funds or property are derived from or used in connection with criminal conduct or any matter on which such a suspicion is based. Now, again, they say police officer because this includes everybody, not just the financial services providers. Of course, you would report yours to the FIU. The FTRA makes it very clear. FIU Act makes it very clear. The disclosure shall not be treated as a breach, okay? Upon the disclosure of information imposed by statute or otherwise shall not give rise to civil liability as well. B, if he does any act in contravention or subsection 1 and the disclosure relates to arrangement concerned, he does not commit an offense under this section if the disclosure is made before he does the act concerned and the act is done with the consent of the police officer. Again, if you do your review and you are suspicious, again, I would think and tend to think that you would do an oral report quickly to the FIU, and you could also call the police, especially if there is knowledge, not suspicion anymore, it's a knowledge thing. Okay? The disclosure is made after he does the act, but is made on his initiative and as soon as it is reasonable for him to make it. Now, I gave you an example of the bank that had its correspondent account seized. That particular order of seizure was a 90-day order. Now, in your mind, is it reasonable for them to wait 2 days before it expired to come and tell us? The act said reasonable. Okay? It has to be reasonable. 90 days, if we had put them before the courts, the 90 days, 88 days, definitely wouldn't have been reasonable. And of course, I blew my staff at them. All right? I read the Riot Act. And we had given it to the police to take care of. I'm not sure exactly how it came over. Okay? Oh, jeez. I forget this. Okay. Acquisition, possession, or use of proceeds of criminal conduct. And this is section 42(1). Person is guilty of an offense if knowing, suspecting, or having reasonable grounds to suspect, that's the mental, that any property is or in whole or in part directly or indirectly represents another person's proceeds of criminal conduct. He acquires or uses that property or has possession of it. Now, of course, my Grammy always say, the receiver is as bad as the thief, right? It is an offense to charge or committing an offense under this section that the person charged acquired or used the property or had possession for adequate consideration. Remember the example I gave you? And I was saying, I remember how this guy says his name again. Kozini? That's his name, right? Yes, that's his name. Because I always call him Kozinski. I don't know why. It's so Russian, you know? Kozini. If Kozini was selling his mansion in Life and Key for $20 million, sorry, it's worth $20 million, but he put it up for $1 million. That definitely is not adequate consideration. It would have been a good deal. I mean, we could get together and form a corporation and buy that, and each one of us could live happily ever after once we flip it. But it will not be adequate consideration. You would have a hard time if you put before the courts to substantiate adequate consideration for that mansion. Behind the gate, in the first instance, the property alone is probably worth $5 million. It said it is an offense if you had possession of it for adequate consideration. So a lot of times you see these things being sold and knowing about deals, and you need to be careful. I think the only way we're going to get a lot of STRs flying all over the place eventually is to do what the United States did to that vice president of that bank in Chicago. Somebody's going to have to be the sacrifice.
Yeah.
And once a high-flying, high-profile person is sacrificed on the altar of money laundering offenses, then we're going to have the STLs fly. Because I'm sure there's more suspicious transactions than the FIU gets every year. It has to be. Our system is just too big to have a couple here and a couple there and hardly anything from the lawyers or accountants. Most of it still comes from the banks and trust companies or the other financial service providers. Hardly anything from the other providers. And they have deals, because they are individual trustees and all the rest of it. Well, we are looking at something right now in the group of financial services regulators, perhaps to register these individuals who are trustees, not just the companies. Because there's a lot of business going on with individuals acting as trustees. They should be under the same regime as the banks and trust companies and the other financial service providers, if they're doing business for profit. Now, some people do it, you know, for family and friends and whatnot, that's fine. But if they're doing it for profit, then they should be under the same regime. We need to get it all cleaned up before CFATF comes along. Okay? For the purposes of subsection 2, oops, let's see if I can alter it. You need to give me that, I think, you know. Subsection 2, a person does not acquire property for adequate consideration if the value of the consideration is substantially less. Now that ain't me, that's the act. Substantially less than the value of the property. It's exactly what I said. Okay? You cannot hold it as a defense if it's substantially less. Alright? B, a person does not use or have possession of property for adequate consideration if the value of the consideration is significantly less than the value of his use or possession of the property. Okay? So a person does not use or have possession of the property for adequate consideration if the value of the consideration is significantly less than the value of his use or possession of the property. So again, be very careful. It's very easy to be duped into expensive gifts. Be very careful. Those clients that are willing, some have good hearts because they're benevolent and they're multi-millionaire, billionaire types. They give you a gift, but you gotta be careful. Why are they giving me this gift? I am highly suspicious all the time. I am serious. I am highly, and I think it's my regulatory background, I'm highly suspicious all the time. 1 year, this bank sent me a case of this very expensive wine. First of all, I don't drink, but I didn't even know how much it cost because I opened it up and my executive assistant said, "Oh, Miss Nordich, these things cost a lot of money." I said, "Send it back." Call him and tell him send it back. "No, Miss Nordich, I said, "Send it back." I said, "Don't you open one of them." Oh gosh, we have some times. You know, I have seen some gifts. For instance, 1 year the guy, what did he do? He sent me, it was in the case of wine. It was this expensive perfume. And again, I'm not lavish like that. Oh, it's not nice, but I gotta know $200-300 on a bottle of perfume. Again, because I don't. My executive says, "Oh, Miss Nordich." I said, "How much that thing cost?" She said, "What an expensive." I said, "Check how expensive it is." They have a laugh at me because I cut a long story short, I didn't accept that. We have to be very careful. And as a regulator, be doubly careful. But as a professional, you need to be very careful. And not say, you know, you know, a cruise on the Mediterranean. What? When? What date? What time? You know? What are they trying to get out of you? Because the next time they come around, and some rich people are famous for it, I mean, we who are not rich are sometimes a little too. Think of them when they come for a favor, and you have taken a substantial gift from them. How are you going to back out? They have drawn you in. They have drawn you in. So be very careful in dealing, especially with substantial clients. Okay? Supervision of any person of services or goods which are assistance to him in a criminal conduct shall not be treated as consideration for the purposes of subsection 2. Provision of any personal services, I guess, or goods which are of assistance to him in a criminal conduct shall not be treated as consideration for the purposes of subsection 2. Okay? Another safe harbor for the professional. 42.8 provides for the employed person to enjoy the safe harbor of aforementioned if such persons makes disclosures. This is why you have to have a proper system in your licensee, in your FCSP, in the insurance or securities broker, or whoever you deal with. If you have the system in place, you are actually setting up a safe harbor for the employees. If they make the proper disclosures to the appropriate person in accordance with any procedure established by his or her employer, as they have effect in relation to disclosures and intended disclosures, again, they have to a police officer, because this proceeds the Crime Act, it will be to the FIU. But if you were brought before the courts and the STR did not go in, they cannot lay it in your charge. You did it in accordance with the procedures in your entity. And that's why I always tell people, document, document, document. Especially at your workplace, document. Because if it gets up to somebody who in their wisdom decided that this is not an STR because these guys are bringing in billions of fees, and then the regulator goes in there, the Securities Commission or the bank goes, central bank goes in, or insurance commission, whoever, and said this is a suspicious transaction, and we file it, and it become a case, then they of course are going to go to the people who are responsible for filing, because there are obligations and there are fines for those people if they don't. You would have some kind of defense. Okay? And I think the law put that in there because they know. I mean, the framers knew. The business people will always want the business. They're going to fight against you. Because guess what? Hopefully their bonuses are not tied to those fees, but if those bonuses are tied to those fees, you're going to go 10 rounds. Okay? And most of the time, if you don't have no support upline, you're going to get knocked out. That's why we have that independence thing that I was talking about. There needs to be an independence line of reporting, either to the board, if you're standalone, or to your head office compliance or regional center, VP or whatever at head office, because you need to be independent, although they pay you your salary, independent from the business line. You just have to be. Because your purposes clash, and they will clash all the time. You're looking at the bottom line, you're looking at safety, you're looking at reputation. And sometimes that don't come with the bottom line. There's some business you have to let go. Okay? Okay. 43.2 deals with failure to report. And we've been talking about it all along. You have failed if you have not reported something that you know, suspect, or has reasonable grounds to suspect. Now, our law is very strong. Some laws just have know or suspect. We go to third round. It mightn't fully be there, but the reasonable man on the street test, we're professionals. So if you go to court and you stand up there with your degrees or your experience, I mean, you've been in the business for 30 years, right? Been in the business of banking or trust or financial corporate service providers or insurance for 30 years. You set up a structure for this wealthy family. Didn't get the proper CDD documents to verify source of wealth, source of funds for the transaction that they were doing. You didn't even document properly that this person was born in Algeria, migrated to the United States, resident in the United States, and his children are in Europe in school. And of course, he happened to be a pet. So let's put all that in it. You aren't documented properly. You know you're in trouble, right? Big trouble. Okay? So, again, reasonable man on the street with one eye, half a hand, or half a leg, know that that man might be doing something wrong. And you haven't got your proper documents to monitor. So, if you fail to disclose, you're in problems. Alright? The information or other matter on which the knowledge or suspicion is based came to his attention in the course of his trade, profession, business, or employment, and he does not disclose information or other matter to a police officer. I'll put the FIU in there as soon as it's reasonably practicable after it comes to his attention. Okay? He is guilty of failing to report. Now, we got to get the tip off as well because it's so difficult. We had a case just the other day. The man was complaining, and I realized right away his account is probably blocked because of an FIU order. I think it's as serious as that. And he wanted to transfer the balance out of the country, out of the bank to another country and stuff like that. And he's complaining. He sent emails. His lawyer has talked to the bank, and the bank is not responding to him. The problem is they cannot say much because of the next offense. Okay? You have to be very careful what you say to them. This is just a piece from the FTRA. They're saying how it is to be done in writing. Urgency, you could have oral, then follow it up as soon as possible. And again, it's just not an offense under the POCA. It is an offense under FTRA. And I'm not sure how the courts do it. I don't ever want to find out. But they have fines under FTRA for the person and the corporate body. And then under POCA, they have fines for the person. I don't think they have anything for the corporate, but for the person, and that will probably be the MLRO. So you have fines for both. Now, tipping off. That is why you need a system in place for reporting, apply, because in certain circumstances, you have to put a blind shield around whatever it is. There comes a time when the investigation is at a point where a decision has been made whether this should be reported or not. You have to cut off certain people. It will be on a need-to-know basis. All of this should be documented. Your system should be documented so everybody understands what's going on. Okay? You have to cut off. Need to know. And Tashira knows I was talking about, it's not just in this, I mean in regulatory matters as well. The same system is in place. If a licensee is about to be intervened or there's something going on, there's a need to know. Everybody in the department will not know. You would keep that at a level where the decisions are made and then all of a sudden certain actions happen. Because you want, there's an element of surprise sometimes in our interventions. But in here, it could be very, very nasty. And we had a case. We had a very nasty case. An MLRO reported a matter to the FIU, but somebody within the institution was chummy. Like I said, you gotta be careful with how chummy you are with the clients. They were chummy with the clients and they told the client.
There was a gentleman, MLO. He was actually threatened. His life was threatened. It's a serious matter. And so you must put in the proper processes, the proper processes, so that when it comes time, things are on a need-to-know basis, because it could be life and death. That's how serious your job is. Because some of these guys, I mean, especially if you're about to report or you have reported and the investigation is not complete, you must understand, especially if they are money launderers, they will stand, I mean, they will go to any lengths to protect what they have. And that's why the systems have to be in place, okay? So tipping off, if you know suspects, yeah, in connection with the investigation being or is about to be. That's why you have to know when to cut off the information. It's about to be conducted into money laundering, and he discloses to any person information on any other matter which is likely to prejudice that investigation or proposed investigation, they are guilty of an offense. Okay? Grounds to suspect, yes. So if he suspects, yes, and he discloses to any person information or other matter which is likely to prejudice the investigation, he's tipping off. And we have a small community, people. You'll be surprised. I'm always surprised. Persons have no connection name-wise, and then you find out later, that's cousin so-and-so. You know, she just married somebody that, or, you see what I'm saying? Or she even changed her name, because I had a lady that was Farquharson. Later on in life, she became Farquharson. So, no, seriously, people change their names. You see what I'm saying? And anyway. It happens, people. Now there is a thing, I know the lawyers are saying, when are you going to get legal privilege? Yes, there is legal privilege. However, okay, nothing in subsection 1 or 2 makes it an offense for counsel to disclose any information or other matter, yes, to or to a representative of a client or his in connection with the giving of advice by the counsel and attorney to the client or to any person in contemplation of or in connection with legal proceedings and the purpose of those proceedings. Those are confidential, right? If it's proceedings. But this subsection does not apply. You can underline it when you get your notes. Not apply in relation to any information or other matter which is disclosed relating to criminal conduct or with a view to furthering any criminal purposes. It doesn't apply. It does not give you the right to hide crimes. Okay? As several of you are lawyers, you're covered in here for your legal privilege and what you shouldn't be doing. Okay? Now the penalties. And if you haven't read the act, I know some of you always say, but what can it be liable for? Well, this is it. Under section 45(1), with offenses under 40, 40, and 41, and 42, on summary conviction, to imprisonment of 5 years or a fine of 100,000 or both. Now you know as professionals we wouldn't last a day up in Fox Hill, right? We wouldn't last a day up in Fox Hill. Okay, much less $100,000 fine. That's a whopper. Okay? Now, my legal mind. Summary conviction is magistrate? Yes. Okay, that's magistrate. So, and you see these things, it depends on whether you find the magistrate in a good mood. Now, the law, I watch a lot of Law and Order. I watch a lot of Law and Order, and I believe it's true. That magistrate had somebody in his past, did something and did it, and boom, you could forget it. I don't care how they say what they say, impartial. You know, human impartial. Takes a superhuman.
to be impartial. Their belief systems come into it, their experiences come into it, and they try as much as possible. But honey, that's what I told them, never put me on the jury. No, never put me on the jury. Mr. Knowledge could attest, his cousin, my husband, was shot 4 times. Never put me on a jury. Because whoever they put before me, they're guilty. Oh, they're guilty. They might be guilty of that, but they're guilty of something. They're guilty. Every time my name come up, I call, I said, if y'all know what's good for the system, it will take me off the list. And they took me off for years and years. I think about a couple of years ago, they started putting me back on. So I call them again. I say, y'all really want me on there? I'm the spoiler. They guilty. Okay? I don't care what evidence you put in front of me. I blind to that. 4 bullets went in his body. Sweetie, they guilty. That's all I can say. Okay. On conviction on information to imprisonment for 20 years or unlimited fine or both. Lord help you if you're in a good bad mood. Unlimited fine or both? Money.
Any amount
That's the Supreme Court. Supreme Court justice is saying $1 million. Of course you could appeal it because it's unreasonable, but you're gonna have a charge against $1 million. Don't let him be in a bad mood that day. Okay? And 20 years? You'll die just thinking about that in jail. Okay? Section 45(2), a person is guilty of an offense. Section 43 and 44, that's tipping off and failing to report. Okay? Your sentence or fine is a little less. If you could call 3 years and 50,000 less, it's relative to your situation. But again, in magistrate court, they could go for 3 years or fine of 50,000 or both. And that's for tipping off or failing to report. Okay? On conviction, the Supreme Court justice, he gets more latitude, 10 years or unlimited fine or both. Okay? And remember, the FTRA has its own little fines when you add that on top of that. See it there. FTRA levies a further penalty, imprisonment of 2 years on summary conviction for tipping off clients. And the court shall, on conviction of the offense, 40, 41, 42, forfeit the property to the crown. Okay? So you'll have a fine over your head, conviction, you go to jail, and when you come out, you don't have nowhere to live. So they really need to strip you. I'm telling you, if we make an example of somebody, he'll be the poster boy for STRs. Okay, now I like little quips and little things that, what should I say, remind me of the substantive provisions. And this is what I did looking at 40, 41, and 42. It's a nice little summary. The relevant broad principles may be summarized as follows. No service of any kind may be provided to any person suspected of being engaged in or benefiting from criminal conduct. All of those pages condensed. That's how I got through my master's degree. I condensed those big books. There should be no acquisition, possession, or use of property suspected to be derived from the proceeds of crime. Reports must be made to the FIU if there is any knowledge, suspicion of, or reasonable grounds to suspect criminal conduct on the part of customers or clients. No information may be given to any person which indicates that a person is the subject of a report or is or may be subject to investigation. So I summarized, I think it was 40, 41, 42, 43, and 44. They're the main money laundering provisions, tipping off and reporting in the legislation. Okay? I just had a note on the guidelines that I was talking about in the beginning. These are practical helps in interpretation of provision and give examples of good practice. That's why you need to look at those. Those who are in securities, they have them on their website, we have them on ours. And these guidelines have the force of law. All of them. No matter who, which regulator issues them, there was something, a provision that was placed in each of the laws to address that gap that was seen by, I think it was the CFATF again, or was it, yeah, I think it was CFATF, or the 2002 review. It had to have the force of law. So what that means is, when we go into your licensees or your companies, and they do not have what we have in our guidelines or something similar, which is the flaw, then they have to prove that their system is as good or better. And that's where you get into trouble. If you don't have the provisions in your system, your risk rating system, because it's in there, your CDD requirements for each category of licensing, it's in there. The reviews, periodic reviews, it's in there. Okay? You will be found lacking. And that's why you have the reports of examination. A lot of licensees like to challenge on certain points and things like that. But when you put up the guidelines against what they have, and if it's lacking, it's lacking. And we have been, I don't know if Ms. O'Brien had the experience, but in the central bank over the years from 2001, we have had, unfortunately, persons lose their jobs who are responsible for this in their institution because of the central bank examination report. Because these reports don't just go to your management team here. These go to the board. And to, I think a copy goes to the parent. So, it's not just the Bahamas that's going to know that you did not put in the systems, the processes, the risk rating that's appropriate for the risk that your institution. We don't tell institutions what risk to take. That's not our business. But when we come in, we review whether the systems in place is appropriate for what risk you decided to take. If you want all of your clients high risk, bully for you. But you can't have your controls lacking. If your controls are lacking, then you're in trouble. We're going to give you a lot of grief. Because you are a risk to the entire system. The risk profile of your institution should be approved by your board, their appetite, where they want to be in that. And it really depends on your products that you're offering. Offshore in itself is high risk. So we don't like to see when we go in there, the majority of your clients are low or medium risk. Come on. Just by the nature of the business, it's high risk. You can't tell me it's low risk. And we're not talking about the clients being bad. It's because the nature of fiduciary services and asset management, and you're dealing with millions and millions of dollars. You're dealing with PEPs. You're dealing with complex structures. That's high risk. When we first went in 2001, we had a lot of, well, the risk framework didn't come in until 2004. We gave a run up to it, and it was implemented, well, it was launched. Everybody had to have it in place by 2004. After that, when we went in and we saw some of the stuff that was put in, even though they produced a system, they sent it in for review. When we got in there, the practice was not there. It's almost like what the FATF said about us in the NCCT process. We had beautiful laws, so you could copy and write and, you know, document. Some people could copy now, and they could patch and, what you call them, paste and whatever. Beautiful. The regulator love this, yes. But when we go into test it, the practice have to be behind it as well. Okay? So again, those of you, this should actually galvanize you to start or looking at what you have in place. Because guess what? If you are the MLRO, if you are the CO, or part of the compliance function, and we come in and you do not have comparable policies and procedures in place, the entire function looks bad. We will say there are weaknesses, there are gaps, and nobody likes to hear those kind of words. There are weaknesses, there are gaps, it needs strengthening, bam, 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 okay? You have to, the institution will be required to demonstrate, not us, the adequacy of those procedures if they are not similar to what we have advised in our guidelines. You have to, okay? Okay, the courts will have regard to relevant guidelines issued by the FIU or the relevant agencies or both. Okay, all of us have that in our guidelines itself. Consistent with the requirements of the law, these guidelines cover internal controls, policies, and procedures. They're very well set out. Identification procedures, which is the heart of what you have to look at for your particular question. Record keeping, suspicious transaction reporting procedures, the appointment of the MLRO, education and training of employees in the procedures, laws, and detection of suspicious transactions. And of course, under record keeping, it's very important. All records must be kept 5 years after the end of the relationship. Okay? So it goes through all of this. Education and training is mandatory at least once a year. And that's another point for your question. Something came up about training. They were misdirected. The training really went to the wrong people. Okay? And that is because of the governance over the compliance function. He was geared towards sales, so the training went to the sales development and all the rest of it. So their system is really weak. I had to put them on watch list. You know what I mean? And enhanced due diligence, enhanced due scrutiny. Okay? But the training is very important, so that section on training is another section you need to look at when you're looking at your question. Okay? Very important. The training should be focused at the frontline people who are going to be filling in the applications, who are going to be taking that information, who's going to do the first review. They need to know what to look for. It can't just be, you know, salespeople still, they need some training, but the training that we want focused on is anti-money laundering training. Okay? We're going through that very quickly. Any questions or queries?
Mrs. Knowledge, there was a case about the article in the newspaper last week about an incident with Royal Bank and a client with this transfer of some 300,000.
I know. I don't know of it personally because
would that be considered part of what you were just discussing, the Crime Act?
No. I think this is fraud. Pure fraud. Somebody stole from his account. He would have had to perpetuate transfers, but this actually went from his account to somewhere without his knowledge. This is fraud.
But the bank, because the bank,
Yeah, but the bank has weaknesses, but if that's what you mean. Yeah, the bank system, but again, it depends. Let me back up. It depends. Why I say depends? Because they must have gotten some kind of instructions. Now, fraudsters could be very good. They could have gotten either a clipping of his signature and place it, and you never know exactly what they were looking at when they initiated the transaction. Now, what they probably could have done, especially if it's outside of his profile, they should have called, verified.
Yes, because
Exactly.
because his normal transactions were $5,000.
Yeah. That is what the bank is going to catch a lot of heat for that, and that's why they put it back in his account. Because
100,000, three transactions of 100,000 each.
It came to about $300-some-thousand.
Yeah, they did.
That is the weakness for the bank. Whoever did the transfers, they should have verified if it's outside of his profile. So that's why, if they can't get the money back, I think the bank is going to lose.
They gave him the money back, but he wanted to speak to the managing director, and he's been dating him.
Well, okay. The thing is, right? That's not unusual. No, I don't mean that. I mean, the tall people not wishing to speak to complainants. Because they have persons in place for that. If he was, say, a very, very substantial client, they will speak to him. I don't know how much his business is worth to the bank, but if he was very substantial, there'll be no, no question. They'll call him in for tea and crumpets, whatever. But apparently, he might not be. He's just started up a new business. Sushi or whatever. So, two businesses. I'm not sure why they're not speaking to him. But he got his money back.
Yeah.
That's the main thing. That's the main thing. I think they want it to go away. He's a broker as well.
Yeah, he's a broker.
So he might be doing substantial business, but I guess they want this to go away. They gave him his money back and they want him to stop.
So that's their loss.
It probably is. Because if they can't get the money back, that's their loss. Okay? Alright, let's see if I can get
You
this
were in
other,
that paper too,
this other thing up. Who's that?
You.
Oh, you saw that, eh? She saw that.
I said this person looked familiar.
Oh, you saw that.
And I read it.
There is none dairy.
Yeah.
There's definitely no instant success.
Right.
I hope my young people took what I said. Okay. How did we do that again? I'm definitely not savvy with this thing.
This is can we do that thing, the other side? That's 2 weeks.
Oh, I did it, no, I told him I had forgotten to give it to him. I gave it to him this morning.
Okay.
But he didn't send them out, I guess. Oh, what's going on here?
Fireworks?
Okay. We're not going to play tonight. Alright, they just wanted, there's a briefing of the other models or frameworks.
Yeah.
And we will do that briefly tonight. And then, either if I have time this afternoon, I'll give you some pointers so you can start working on your homework. And then once we finish CDD next week, then I'll give you the rest of it, okay? Alright. Well, the UK model, this is what we model ourselves after. And you can see the same names, really. Proceeds of Crime Act, the primary legislation for them is Proceeds of Crime Act, and the Terrorism Act of 2000. Their secondary legislation, they have money laundering regulations, money laundering, updated regulations of 2002, and the FSA money laundering rules. And the UK, their rule book is horrendous. It's very, very thick. I don't know how friendly it is, but we took what we thought was best for our system out of these acts itself. Of course, the Proceeds of Crime Act, we did look a little bit further, and some of our provisions may be slightly different from theirs. Okay? This is the landscape for the UK. Substantive offenses, you can see it's basically the same. Concealing, transferring, it's the same wording. But you will note that offenders are not required to know or suspect. No strict liability with no mens rea requirement. Okay? That is different. From our position. Arrangements, the offense is committed where a person either knows or suspects. Again, no reasonable man or reasonable suspicion. That's not there. But if he knows or suspects, facilitating, acquisition, retention, these are the same kind of issues that have come up in our act itself. So we have the arrangement. Acquisition, use, sorry. Let's see. Let me go back. Acquisition, use, and possession of criminal property. Again, I believe in our setting, that probably is 41 or 42? It's probably 41. The same, and I have an MD there. Persons knowing suspected the provision of services may be helping another to commit a crime, they will be guilty of an offense. The person can prove they provided goods or services for adequate. Again, it's the same kind of language. Consideration without suspecting or knowing that they were aiding and abetting a criminal, they will not be guilty of an offense. And this is like yourself. I mean, these criminals got to eat too. So super value probably have money flowing that they don't even know. They got to buy gas. You see what I'm saying? The essentials of life, they got to. And the corporations or super value does not say we cannot accept your money unless we have CDD on you. No. Mr. Roberts wants you to come in and not go to Solomon's or Costrite or whatever. Okay? There's something on that though. Mr. Roberts has been coming in the papers every week about that. I tell you all the truth, start stocking up on your canned goods and stuff. Because they are not, I'm telling you, I could see it, they are not going to ship anything to the Bahamas. He's going to run down his stock and then he's going to ship in after the 1st of July. He's not going to lose. None of the businessmen are going to lose. So we might have a little touchy time going into July. So get your canned goods and stock them up. I know the man. My husband used to work for him. And just as an aside, when he got shot 4 times, that little short man and me, we clashed. My husband got shot for his money because he was an assistant manager at the time. And Mr. Roberts, the doctors didn't operate, they didn't get him stitched up, but my husband on the way to recovery, and the people didn't get paid. I said, who? My husband not gonna get killed for your money? Oh, okay. And you don't want to talk to me? You see, sometimes there's, you know. I took a day off, and I went and I sat on the steps of his corporate office very early in the morning. And when he came, Mr. Roberts, how good to see you. And I locked hands with him and said, come, let's go. And he was so scared. Because I would have knocked his block off if he didn't give me those checks. Oh. I have mellowed quite a bit over the years. No, but by the time I left Mr. Roberts' office, I had my checks. Because he knew, looking at my face, and the sure could tell you, when I'm upset, my face shows it. Okay? So let's get back to money laundering. Okay. They have a test of criminal conduct. The substantive money laundering offenses can only be committed following the commission of predicate criminality, referred to as criminal conduct. They have criminal conduct, fine, and they have it defined. They don't have a list like we do. They have criminal conduct defined. And in the UK, even if it isn't a crime in the UK, and it's a crime somewhere else. Single criminality, that's what it's called. There is no dual criminality. There's single criminality, it's an offense. Okay? They have single. For all intents and purposes, I think we still have dual, because we have that will matter tax. Okay? Now, there's a duty of client confidentiality, and that's a case that was laid down where it was found that there's a duty of confidentiality with respect to information on accounts, but it's not absolute. Just the same way in our acts, it's not absolute. Based on compulsion of law, same with us. When there's a duty to public disclose, did I do something wrong? Yeah. Where the interests of the bank require disclosure. Now that one is the one that came with Scotia Bank in the 80s. Okay? They had to go to court, but they didn't get to court. Where the disclosure is made by express or implied consent of the customer. That's always the best thing. Scotia only got out of going to court for directions to send that information to its affiliate in the 80s because the client consented at the last minute. He had a deal with the US people. Okay, so again, similar to our laws, SCRs are done on compulsion of law, provides for statutory protection against liability arising from the act of disclosure, same as ours. All right, so basically you can see most of the same provisions in their legislation that we have in ours. All right. Failing to report, same. Person knows or suspects. Now this is us, I believe. Let me just see, because I have reasonable grounds in there. Okay, I need to take out reasonable grounds before I give you all this one, because this is still the UK. It's just knows or suspect that another person is engaged in money laundering. Information which is suspicion or knowledge is based, came to the offender in the course of his employment within the regulated sector, and the required report is not made in a reasonable time frame after becoming aware of the information. So basically some of the same provisions with respect to failing to report, except that they do not have reasonable grounds in their law. And B, the offense can be committed even in circumstances where criminally derived property is not laundered. For example, where a potential client is turned away. Remember I was talking about that? That's the same thing, and I have the Bahamian FIU. Even if a client is turned away, you have knowledge. The law does not say, please get that in your procedures, because the people on the front line, they might turn somebody in where you don't even know. But they were going through the process of establishing an account or a facility or whatever. They have information. They should turn it over to the MLRO for a decision to be made to send that to the FIU. Okay? The Bahamian FIU is of the same opinion. And, oh Lord, who was it? She was the legal person there. The registrar, Thompson. When Thompson was there, what's her first name? I don't remember. Elizabeth Thompson. Elizabeth and I traveled to several conferences for CFATF and whatnot, and that was one of the questions I asked her. Particularly, I said, review that. Is there an obligation? She said, yes. But our law covers potential customers as well. So make sure when you're doing your processes and procedures to put that in. It's not just customers, it's potential customers as well. It is therefore possible for a person to be prosecuted should it be deemed that he or she failed to report where it is objectively decided that he or she should have done so. So please, I know I can't come to see you all in prison, so I am not coming to see you. I quote from a recent address by the legal counsel. Again, this is Elizabeth. She used to travel quite a bit. Conferences, I think this was a conference in Russia. Once an employee of a financial institution or business, trade, or profession becomes aware of, has a suspicion, whether reasonable or not, or, and this is her, I'm quoting on, or has actual knowledge that a proposed or complete transaction or activity may relate or does in fact relate to proceeds of criminal conduct under POCA, that employee is required to report his or her suspicions to the MLRO or the appropriate person. I wanted to substantiate what she told me. Okay? So, make sure your procedures are correct. Tipping off. The UK law, again, has tipping off in it. Safeguard the integrity and value of STRs, avoid prejudice of investigations from filings. Okay, there will be a penalty, there will be an offense if a person who discloses then discloses that information to another person. Could prejudice the investigation. Okay, the offense is common to many of the jurisdictions because of the impact it could have on investigations and successful prosecution. Okay? And boy, sometimes, yeah, I put some clapping in there. Sometimes you gotta, you know. I just don't want to. But you all don't mind me. I always say these classes allow me to get some, you know, steam off, you know. She know I'm not like this inside the office. I'm sure she's going, well, who is this person? I never met her before. I know she's saying that. That's the premium. Okay, UK secondary legislation. Of course, they have a lot of regulations, stemming back from '93. That's when they first put in the law, and then of course they started to review it once all the review of FATF came about and whatnot. Because of course, you know, the UK is instrumental in the FATF. Remember I told you the guy who put him on the list? He's a senior person at the FSA. Now, I'm not sure if he's transferred to the Bank of England because, you know, they split them up. But that's my very good friend. Every time he sees me, when after that he wanted to hug me. Okay. Council of Europe. They have to cover the European directives, of course, because the UK is in the system, but not in the currency union, but they are in the EU. So the other directives do cover them. And these regulations, they apply to businesses carrying out activities under the I guess that's the FSA, the Financial Services Markets Act. They impose procedural obligations such as customer identification, verification, records keeping, internal systems. This look like our guidelines, right? Recognition of suspicious transaction, internal reporting systems, staff training, education. Breaches of these regulations of criminal offenses punishable by 2 years and a fine. What does that look like? Our FTRA. So you can see the similarities in the systems. Okay? Come on, Paris. I was trying to get fancy. I was playing with it. Financial Services Authority money laundering rules, regulatory requirements as opposed to requirements imposed by the law. So these, I guess, are like their guidelines. But ours is enforceable by law. Theirs, I guess, is not. The purpose of the rules is to reduce the extent to which it's possible for business carried on by a regulated person to be used for the purpose connected with financial crime. And these are documented in their money laundering source book. That's the very thick. You know, they have to have a whole legal department to interpret. Very thick book. We try not to do that because we know that we have limited resources, and we know for sure you all have limited resources. Because sometimes when we go and we see just one person trying to carry the load, we know you all have limited resources. So we have to be careful with, you know, how we put these things out. Okay, let's get on to some of the others. Most of the other money laundering models, again, they're not static. All of these are product of international initiatives. Okay, as these international initiatives evolve, the European Union directives evolve. The information or the revision coming out of the FATF, there will soon be another raft of revisions around the world. Everybody's working on it now. Once those revisions were published, the FATF, all of the governments had their regulators and their FIUs looking to update their guidelines. And probably even some laws, amendments to laws, because certain things have now changed. So anytime international initiatives or standards change, you're going to have something going on. Most, if not all, primary legislation of notable financial centers have undergone substantial review. This was when I did this. This was like a couple of years back. They're now doing reviews again. Actus reus, mens rea may vary from jurisdiction to jurisdiction, but most are similar to the UK model. And that is because a lot of the substantial offshore international centers are what? Former colonies or colonies. Okay? So you're going to see that we will stay with what we know. We know common law and the English law that was passed down to us. So again, most of us have the same things. The differences between the regimes, when I looked at them, this is what popped up. The mens rea requirement for substantial money laundering offenses, knowledge, these are some of the words, and I don't know what they mean. Knowledge of, hey, suspicion of strong suspicion. What is strong suspicion? You know what I mean? And they don't define it, you know. Strong suspicion. Reasonable grounds, again, that could be argued in the courts. Definition of criminal conduct, the nature of the reporting requirement, the regulation of the industry sectors, the existence of bank secrecy, very bad word now, I need to change that to confidentiality. You know, it's just perception, you know how it is. The treatment of tax evasion, for those who have taxes. Of course, the UK have tax, and several of the other jurisdictions have taxes. So they would have that in there. And of course, the US have what they call, you know, they always like to be different. Yeah, we at the top of the chain, all right? So the willful blindness test is what they call it. The USA applies this test to offenses. This test assumes that a person makes a conscious decision to close their eyes to the crime. This test contains a subjective element, whereas the objective test does not. The objective test is satisfied where a person simply fails to recognize any impropriety in the circumstances where it is objectively decided. Boy, I was really playing with some of those letters. Decided as okay, that he should have done so. Thus, the objective test is easier to satisfy than a willful blindness test. Okay? Because you have to actually prove that the person saw you committing the crime, and he said, well, as long as I don't see him, you know, that's what they're trying to say. I ain't involved, you know, that kind of thing. That's the US law. That's in the US system. And under the definition of criminal conduct, there are three ways to vary the test of predicate criminal conduct. Make the definition the generic instead of prescriptive. Inclusion or exclusion of the test of single criminality. The other side of the coin, some jurisdictions include or exclude the test of dual criminality. Okay, and dual criminality, of course, is where both jurisdictions have the same, it's a crime in both jurisdictions. Single, of course, is the UK, even if it's not a crime in the UK and it's a crime in the other country, a UK subject, resident or citizen can be charged in the UK. Okay? I think I like dual that. Inclusiveness of crimes based on minimum level of punishment applied to the test of predicate criminality. Okay? That's the three ways that they vary the test of predicate criminal conduct. Oops. And I'm going a little fast. It's just that they will give me 5 classes. So next week is my last class with y'all. Yes. Y'all gonna miss me?
Yes. We don't have you on the 19th. You have fun the 19th.
No way.
Yeah,
You sure?
trying to say something to change.
Oh, that's good then. Because CDD is quite a long, yeah, okay, that's good. So I get 2 more classes then. UK, all crimes included, whereas in Jersey, I'm giving you some of the jurisdictions. Jersey, of course, part of the Channel Islands, Crown Colony. Jersey, all crimes punishable by a term of imprisonment of 1 year or more. Some states is New Zealand, dictate a prison term of 5 years. Okay? The Bahamas definition includes a list. So we have a list. Context of sections 40, 41, and 42 of POCA. All crimes are captured. We don't have to, you know, be more prescriptive than that. It's in there. Criminal conduct includes, but it's not limited to, offenses such as so the person who committed the fraud, though, not him, the person who committed the fraud, they would have to get it into another system. On the other side, they should be investigating money laundering because it was the proceeds of crime, but not this gentleman. Okay, let's get back. But it's not limited to offenses such as fraud, drug trafficking, bribery, insider trading, extortion, money laundering, and other indictable offenses which occurred or are alleged to have occurred in the Bahamas or elsewhere. Okay, that's our definition. Belgium gives a long list of crimes similar to the US. In Denmark, money laundering is dealt with under 2 sections of the criminal code, which gives a list of crimes. So you can see most of the centers deal with it in their own way. Germany, all major crimes with a minimum of 1 year's imprisonment are included. Trafficking in people, illegal trade in drugs and arms, less serious crimes that do not attract a year's sentence, such as illegal trade in narcotics. That is strange, but that's what it said when I did my review. So, if you're into drugs, well, that is drugs. Illegal trade in drugs, illegal trade, I guess it's different dilutions. Maybe weed versus cocaine.
Some things are legal in certain places like that. So, it depends on what the definition of drugs is compared to now.
I guess you go to Colorado, you can smoke all you want. Greece has a laundry list as well. Spain, Austria refers to all serious crimes carrying a person for a prison term of 3 or more years. Yes, France, Finland includes all serious crimes. But y'all really have to review your client base, you know, because y'all got a lot. I think what you could do, you know, those little snapshots, if you have a dashboard, you need to look at all of where your clients are from, because that's a part of your risk rating system. And you need to just put a line or so you have it all in one place, because if you have clients from all over the world, you're in trouble. But most of the licensees or FCSPs have a certain area, be it Latin America, maybe Brazil, Argentina. No, y'all have it all over the place. You're in trouble then. Make sure you have, if you apply for trust, make sure you have enough people to cover all those places, or you will decide it.
You mean this is just me?
I need to get a license. Sweden crimes carrying a sentence of more than 6 months. More than 6 months. That's short. Cayman has instituted a dual criminality test that requires the predicate offense to be unlawful in both countries where it takes place. That's like us. Bermuda, Guernsey, Isle of Man follow the UK model, single criminality, and all crimes. And over the years, I just put this in for good measure, it's become a very bad word. Tax evasion scams generally include dishonesty, misrepresentation, or deceitful concealment. And again, remember, even in our system, if a country brings a fraud case against their citizens, they probably will be successful under our fraud statute. But of course, they're going to have to document and show that they submitted incorrect tax returns and whatnot. And they've been doing that to some very famous people lately. This kind of activity may be caught as an offense within the tax laws of a country, or capable of constituting a common law offense of fraud or forgery, false accounting, or cheating in the Bahamas. Okay? So there is a back door. They haven't used it a lot. I don't have a case in my 35 years where a country has used it. I think what they have been doing is trying to get you to change your law instead of going through the back door, because it's harder. They got to bring all this documentation and whatnot. So they're trying to make it an offense here. Okay? OECD? Yes? has served to push most jurisdictions away from the common law principle based on sovereignty of nations established in the Government of India versus Taylor, which ruled that the English courts could not entertain any action to collect taxes that were owed to a foreign jurisdiction. Now we have a case, but they're going to test that soon, okay, with FATCA and them coming up. I saw the director, Nicola, was in the papers not too long ago, where the U.S., their bully self, so they just talk for themselves. They was trying to get the Bahamas to put in our FATCA legislation, I'm right? In our FATCA legislation now, that they deal with all of the other people like we dealing with them. You know what I mean? You know what I mean? They want the same provisions that we would allow, or should I say impose on the banks, with respect to clients from their jurisdictions, with respect to tax declaration. Can you imagine? Well, I'm so glad our government, or perhaps it's Nicola, she ain't in trouble yet, eh? Stand up and say, no, we'll only deal with you. This is something for the U.S. and the Bahamas to agree on, and that's the way it's going to stay. We're not dealing with nobody else. The OECD report encouraged international action to deal with tax and related crimes and tax havens. Okay? Cayman and those jurisdictions with dual criminality clauses that are tax havens stand out. Okay? We do. Switzerland and Luxembourg specifically exclude tax evasion as a predicate offense. And we all know what's happening to Switzerland right now. Both nations are part of the OECD and can elect not to buy into tax initiatives of the organization, but they're facing pressure from the OECD to amend their laws or face sanctions, and that was in 2002. But it's gone past that now. The United States has cracked the back of the Swiss Bank Secrecy Code, and they're going after any and every bank in Switzerland, and they're scattering because the government of Switzerland is bending to the pressure. Information is flowing to the IRS. Persons are being put before the courts, okay? And this all came about, it started with, I think it was Liechtenstein, when one of the banks in Liechtenstein, a gentleman who had privy to a lot of information, put the information on his little stick, jump drive, and he took it to Germany and gave it to the authorities. And that, the whole Pandora box started to unravel. Okay? Again, EU tax directive has been, well, this was when Bush, I need to just tie this up a little, because this was when Bush rebuffed them and it went away until Mr. Obama came to power. Alright? So it's back on the move. The UK model has both subjective tests of suspicion, knowledge-based indirect reporting requirements for all crimes, and objective mandatory reporting requirement for all crimes. Bahamas, we have subjective tests, suspicion, knowledge-based indirect reporting requirements for all crimes, for all persons. However, the FTRA issued a mandatory reporting requirement for financial institutions, and that's the list. Persons always question why we have the casinos in there. So they're financial institutions. The millions and millions of dollars that go through those places, they probably rivaling some of the banks. Most other jurisdictions limit direct reporting requirements to drug trafficking and or terrorism, Jersey and Bermuda. Variants on the reporting requirements may include reporting on unusual rather than suspicious. There may be a higher test of certainty where such language as strong suspicion or well-founded, and that's even worse, well-founded suspicion. I don't know what that means. Upon completion of the current review, which is already done now, there may emerge in time a greater commonality of the test for reporting transactions. And I was supposed to get to legal on that to see whether they did. They didn't, eh? They didn't touch suspicious transaction reporting.
Karen said she's waiting on them to hear back from some feedback from them.
Okay. Well, I'll be sure that I send out something to the Institute so we can update you, because they are looking at that now. not sure whether they touched the commonality the test for reporting. Most, if not all, countries issue regulations with respect to anti-money laundering. The variance in the regulations pertain to scope instead of content. For example, some pertain to participants in the financial services sector, while others may exempt lawyers and accountants. Jersey, the Bahamas, Jersey and the Bahamas, the former, meaning all financial service providers. Jersey, the latter, they have exempted lawyers and accountants. And the USA have exempted only lawyers. And I think Canada was challenged by their lawyers. I'm not sure if that's settled, but I believe the lawyers won in Canada as well. There are significant differences in supervision and enforcement of regulations depending on whether particular industry sectors are licensed or regulated. Okay? Before 2000 and the blacklistings, a lot of even the offshore centers that are common law that followed Britain, US Britain system, did not regulate financial corporate service providers or trusts, because they look at those as financial services providers as well. In Britain, they still don't. Okay? But Bahamas, like I said, already was licensing and regulating trusts from 1965. So we stood out in a good light. So I was put on the committee that was looking at the trusts and corporate service providers, and we put out our standard for service providers. And actually in the standard itself, you can find it on the group of international financial centers, because we changed our name. They pressured us. I told them, it doesn't matter if you change your name. I stood out almost as a lone voice. They say, even if you change your name, they're not going to like you. So you might as well leave it at OGBS, which was the Offshore Group Banking Supervisors, but they changed it to the group of international financial centers. But what it did was try to galvanize support for a standard for trust corporate service providers, and it actually now is gotten into the FATF revised. Some of the language, now you have in FATF revised 40 saying, you know, it has to be either regulated or monitored. So again, they would not give us any credit, of course, but it's our campaign to get all service providers, because they pressured us to do it in offshore, regulated, licensed. Okay, we'd like to see how the UK deals with that, with their trust providers. The situation has caused and continue to cause regulatory arbitrage, and that was our problem. We were doing it in the offshore world because they mandated and they commanded us to do it, and they were not doing it. The USA still have Delaware, actually they still have bearer shares, and Switzerland of course still have that. The UK and several of the G10, G7 countries do not regulate, they do not license these providers. Okay, so you have arbitrage going on. All right. Again, bank secrecy was just a coin for privacy rights. And let me tell you, although they're up in arms about bank secrecy, the US, you can't get nothing out of them. Nothing. Nothing. I don't care who you ask. They covered the information on their clients like a steel curtain. Like I said, when I was in Norway, the Norway guys were asking the US, they sent a request almost 6 months, the US did not answer, and they were going back and forth like the children. Rowan, I did a test, never got no answer. But the problem is, and I told you all the problem, we have no stick. So when you don't have any stick to beat back, I'd like to lick some of them. When you don't have no stick, then you try to deal with the situation as best as possible. And of course we did that based on our handbook, so they could send the request through the right channels. Okay? But secrecy, everybody still have to have it. You have to have it. But a challenge is going to come soon in the domestic market when credit bureau come on. Our laws have to change so the credit bureau could get negative and positive information on all people that are dealing with banks in the domestic system. So people, please get your house in order, because when the credit bureau comes on, negative information in your profile will cause you to have high interest rates. The persons who are very good debtors, they will have lower interest rates. And it's not just the banks, it's going to be spread to any company in the Bahamas, like big apartment complexes. People rent, they will know your business because they're going to be putting in information as well. Once they put in information, they can get information out. The utility companies will be invited as well, so you don't pay your utility bill. It's going to be out there. Furniture Plus. Furniture Plus will be a part. You know, we had an issue. Let me just go off it. We had an issue. 2008, the crash happened, right? And then you had the cry, nobody paying their, you know, some people not paying their mortgages, they can't pay because they lose the job, blah, blah, blah. We called the banks together, we said, well, you know, guys, you gotta be good stewards. Persons come in, restructure. So that was the first wave of restructure. 2009, some people came in, restructure. So we get a lot of information in Central Bank, and I was like, okay, let us know if these are the same people who are coming back for restructuring. And we found what the banks were saying, our clients, we combined and consolidated their accounts so that they have one payment, and then they go to Furniture Plus. Then they go to, and now they have a lot more debt out there. They want us to consolidate again. So, guess what? The credit bureau will stop that. Because Furniture Plus will see, hey, you might get paid because they owe the bank and credit unions, and so it's going to be, the system is going to have a whole lot of input. But of course you're going to be like the credit score in the States. You will have one free report to make sure there's no erroneous information on you, but by that time it's going to be too late. So lay up your order, okay? But bank secrecy is going to have to go through a change in order for that to come around.
Yeah.
All right?
Because there's no such thing.
Huh?
There's no such thing.
As well? Oh yes it is. Yes it is. We've had cases where persons in the commercial banks opened their big traps because it was too juicy not to, and they have been fired and brought before the courts for breach. You can be. If they have evidence, and be
That's
careful
the
now.
this thing though.
No. You can't tell me that the phones ain't tapped. The phone systems now in most business places can record whatever you're saying, because you ain't supposed to be talking nothing but the man would.
That's in the
Plus,
business place.
in the, where you think some of that has happened? Too juicy to wait for home. And your computers can be tracked where you go. And you can see that most of them, the serious business will block sites that you can't even go to. So if they can block sites, they're tracking you because you're not supposed to be doing nothing except. So how are you going to get the information? Sometimes you have fools, sorry, they would actually download information and print it off. Oh yeah, some people are fools. Okay, let's get back to secrecy. Some secrecy provisions are prohibitive in nature and are enshrined in law with penalties for unauthorized disclosure of client information. That was Switzerland. Bank secrecy is lifted in most cases for STR reporting, court orders. Switzerland, it used to be, it couldn't be lifted for tax evasion. That's a thing of the past. Okay? When you get your notes there, you say no more. They have, a lot of inroads, and of course, the whole thing started at this time, but the UBS whistleblower, that just blew the whole thing open. Okay? The Bahamas, we have confidentiality, okay? And we have this nice little piece in there, without express or applied, some stamp, disclosure. relating to identity, assets, liabilities, transactions, yeah? If you reveal anything on persons, it's an offense. It's an offense, okay? And the regulators are under the same obligation as you. Probably even tighter, okay? So anything juicy going on, we gotta bite our lips or go in the bathroom and talk to ourselves. Provisions can be breached pursuant to a laundry list of exceptions, which include the reporting under provisions of law, facilitate criminal proceedings, disciplinary proceedings, cooperation between domestic and foreign regulatory authorities to allow the governor, inspector to carry out his duties, or the Securities Commission with respect to their channels of communication. And we do, those channels of communication, people have tested them. Foreign regulators have asked for information. If we haven't gotten orders, then we use what we have to cooperate, let's say, in as diplomatic a fashion as possible. We do have our legal people review it to make sure it's appropriate, let's put it that way. Because there are times when they ask for information, the central bank cannot give any information for criminal matters. So it's very easy for us to say, oh, we'll refer you to the AG. Not so for the Securities Commission. They can give information for criminal and civil matters. So again, that makes it a bit more tricky for them. But we can give information, okay? Cases where sharing of information with fellow regulators are concerned, no fishing expeditions, we don't allow that. Full information as to the purpose of obtaining the information is requested. And usually for us, it's for consolidated supervision, administrative reasons, civil sanctions. Again, criminal proceedings for us, AG, SCB can do both. After appropriate determinations and considerations, deliberations, information is transferred. We in the central bank, we have that power to call for anything from anybody to facilitate our responsibilities. But even if we get the information in, the inspector has to deem it appropriate. It depends on what they say they want the information for. If it's for risk purposes with consolidated supervision, we do have group banks here, and it's only reasonable that they know the overall, should I say, risk that a group, say, let's say for instance, who's worldwide? Starbucks. The risk that Starbucks poses, say, to Bank of America. Okay? For risk matters, that sort of thing. Consolidated supervision, certain things are facilitated. Okay. That's it for second slides. I will send those on to that young man. I will send them on to him. Now, since we have a couple of minutes, with respect to, okay, those of you who have, okay, well, let's just, a snippet here. This is a company, it's global, 25,000 staff, multiple jurisdictions, customized services, products delivered through a range of distribution channels, including face-to-face branch networks, and a series of agent networks. So you're talking about middlemen, okay? Face-to-face branches, a range of administrative services outsourced to Indian subcontinent. So outsourcing is involved. Regional businesses, get ready for this now. China, Russia, Mexico, Nigeria. They made it very easy for you. I think the four of them are high-risk countries. For different reasons, but they're high risk. Okay? So you know you're looking at the CDD, enhanced CDD, and all the rest of the DDDs. Okay. Now, they had an examination, all right, by their regulator. They have, they found that the MLRO don't have enough resources, okay, for the business they have, 25,000 people, you know, transactions going on, volume high. They had a growth year on year, 15%. So there's a lot of work here. Number of transactions and the bottom line, improving over the last 5 years, but she or he has put in requests for further resources which have been declined. Red flag. Global MLRO reports into head of operations. Red flag coming up. He has a twin reporting line, the global MLRO, into the COO, a twin reporting line into the COO, and the global head of business. Serious conflict of interest. The latter is a member, global head of business, board of director. He's a board of director. They have a very bad culture with respect to compliance. They are sales driven. Okay? Their culture is go get the sale no matter what. AML, who needs it? Okay? And I say that because it says right here. The global head of business, who the MLRO reports to, believes that AML controls at the point of sale are unnecessarily costly and potentially inhibitive in terms of volume of sales and staff time. They paint you a real picture. The negative culture was adversely reported in the examination report. So the regulators have noted it. They do not have a culture of compliance. Okay, now for the report. The report said the firm's approach to CDD was very light touch. That's another clue. Jurisdictional and product risk ratings needed to be addressed, given that hardly any of the clients against were rated above median. Remember the 4 countries? Yeah. Okay. The firm had not submitted any SDRs, not one, any SDRs over the last 2 years. The firm's training budget was spent exclusively on sales development and techniques for staff. And then you are asked to do a money laundering risk analysis and recommendations to manage the money laundering risk in an effective manner. Now there's a lot of things going on here. Okay? Whole lot of things. There is country risk through the roof. And remember, as regulators or I guess it'd be a consultant there, because you're asked to do the risk analysis and the recommendations. You have to be objective and looking at what your guidelines and the AML guidelines that the regulators have put out and your notes that we're going to go over. We'll start looking at them for next week because they have some good notes in there. The first things you need to do as the consultant, I think, is to review the risk profile. A lot of indicators here. You know it's high, but then you substantiate. You can't just say high. Analysis, high. No. You better go through it, okay, and say why. So you are doing an analysis. And I think before you do this, you either get securities guidelines or our guidelines and look at the risk rating framework that we have in there and some of the criteria that we look for. Because it will give you a good idea how we look at the jurisdictions, and of course at the back you have an appendix of the list of, I don't know if it's approved jurisdictions, but you know they have supposed to have AMLs on our standard. That will come into it. You'll see that some of these ain't there, probably none of them there. Okay? It has to factor into that. With respect to the services that they do, customized services and products. Again, we don't have enough information, but it looks like it could be a money transmission business, which in itself, going into these countries would be very high risk. It's a customized, you see, so it could be like client accounts with respect to clearing MasterCards or stuff like that, but it probably is a combination of things. But have face-to-face and series of agent networks. Again, if you are going through agents, you have to review them. Alright? You have HR risk. because the business is growing, they don't have enough manpower. And of course, you have the serious conflict of interest with respect to the reporting lines. So that needs to be mentioned and managed. Remember in the beginning I said, look at our corporate governance guidelines, because that have in there the test of independence and certain other things with respect to MLROs and COs. Okay, so the governance structure, after you've done your couple sentences, the recommendation would be to restructure the governance of the compliance section, and you need to say what you would do. Okay? The culture is definitely off. So a lot of training. There have to be, again, you know that most laws that we went through, most laws have a training element. So they're in violation. In analyzing, you need to bring that out. They have to be in violation of the training requirement in the laws. And then you need to pinpoint some of the things they need to train on. Okay? The culture needs to change, and the culture only changes, and I think the guidelines probably mentioned, the compliance culture should be what? Top down. Because if it's not top down, then it's not going to be implemented. It's not going to be supported. And in analyzing, of course, you do in-depth reviews or interviews, and you would find out where everybody's head is. Okay? So you're looking at assessing their risk rating systems, because that's been pointed in the report of examinations. It's not appropriate. You're looking at, once it's assessed, then putting in the various CDD requirements for your different categories. Because there's some things you have to assume here. They're not giving you a lot of information, so you have to assume. If it's this bad, then the category is probably not lining up with what they're supposed to. And in the guidelines and stuff, of course, enhanced due diligence, PEPs and high-risk crimes need to have an escalation upward. So all of that needs to be considered. And of course, with the STR, that probably there probably needs to be some testing of their transactions to see whether there was any breaches, reports not being done, and then again, you probably will find some breaches, because with this kind of business, these kind of countries, there's bound to be some suspicious to do. So you're looking at revamping not just the risk rating system, but probably the process of filing or monitoring with respect to STRs and unusual transactions, I would put it. And then again, you have to tackle the training. You have to tackle the training. That's why the woman needs, or the man needs, some resources, and they refuse to give it. It was rejected. That should figure big. Nothing's going to happen unless they put some resources in. And that need to come out. Because with growth 15% year on year, you need resources. And 25,000 people, you need resources. In each of these regions, I would think she needs at least, or he needs, like a group of people that will filter into head office. And of course, there's a whole lot of stuff around that. So this is a very good, I think, y'all should all get an A. That's 100%. There should be nobody failing. So you'll have some reading to do. Go download that thing off the internet, or read the AML guidelines, the corporate governance guidelines, and especially that section in there. I mean, for sure. I mean, it's really, it is but it's not too thick. It's not too thick. It's on the Central Line website or the SCB website. On our website, I'm not sure SCB how they have it, but it's on our regulatory framework. And once you hit that, the category will come up on the left-hand side. Money laundering, the guidelines are right there. Okay? I can scan it in about an hour to work. Just put it down before your head hit the pillow. Because you will go to sleep. Okay, so I'll see you on next Wednesday. Thank you.
I have a question.
Yeah.